Good afternoon, good morning, good evening, everyone, depending on where you are joining us from. Welcome to this webinar series. My name is Josephine Chinami, and I'm just going to give brief welcome remarks representing the Zimbabwe Environmental Law Association, which is a public interest organization that is based in Zimbabwe, Harare, that works on different issues around natural resource governance, business and human rights, environmental justice, and sustainable utilization of our natural resources. So welcome to the second edition of this webinar series that is titled Bridging the Gap, a Stronger Binding Treaty for All. This webinar series is brought to you by the Business and Human Rights Resource Center and partners, including ZELA, Center for Applied Legal Studies, Lawyers for Human Rights, International Commission of Jurists, among others. This is a space that was created to elevate the work and the voices of civil society organizations that are working to promote or that are working around the legally binding instrument at the UN level, on business and human rights at the UN level. So this second edition is going to look at specifically regional perspectives on the treaty. Recently, the new text of the treaty was released by the UN. So speakers from Latin America, from Africa, will be sharing their perspectives and some of their key issues on the treaty. And the intention really is to determine some of the commonalities that are there amongst the regions, and also help civil society organizations in the Global South to align their messages and lead a more powerful advocacy on the 9th session of the negotiations for the binding treaty. And to drive us or to lead us in the discussion will be Siko Lutango, who is a program manager for labor relations and economy at the Rosa Luxemburg Stiftung. She was also a research fellow in the German Institute for International and Security Affairs. Her focus is on mineral governance across the supply chains from a feminist and socio-ecological perspective. So I do wish everyone who's joining us the best, and let's engage and share perspective on the treaty, perspectives that represents our respective regions, our respective countries, and our respective communities, such that we push forward for a strong legally binding instrument. Siko, over to you.
Thank you very much, Josephine, for that wonderful introduction. We will first begin the webinar with a keynote address by Lihle Mabuza. Lihle is a civil servant from South Africa. She currently works as a desk officer for the Human Rights Directorate in the Department of International Relations and Cooperation, focusing on economic, social, and cultural rights. Lihle will only be unfortunately joining us shortly today and has requested that she be excused following her address. And on that note, I would like to hand over to Lihle.
Thank you, Siko. I hope I am audible. Good afternoon and good evening to everyone. As has been mentioned, my name is Lihle, and I work for the Department of International Relations and Cooperation in South Africa. Firstly, I'd like to just thank the conveners of this gathering in terms of their continued support for this process that we are in terms of the InterGovernmental Working Group, but also creating platforms where we are able to engage on these issues. Because I think actually it's quite important for various stakeholders to always discuss and connect on these issues, whether it's on the continent, but also across the board. So thank you very much. So in terms of what I'm just going to highlight today, I think the topic that is at hand is very, very important. And so I will just highlight the importance of why regional groupings or maybe regional perspectives are very important when it comes to the Intergovernmental Working Group, but also look at the role of South Africa in Africa, look at the current state of affairs briefly, and then I will conclude. So in terms of just as a matter of fact, or starting from the beginning, in terms of how this Intergovernmental Working Group that we find today is a culmination of the work that started when we still had the Commission for Human Rights, and where there was a report that was given to that body that talked about the responsibilities of TNCs or transnational corporations and other business enterprises. And when the report was given, there was a lot of controversy, but also it did speak that in terms of what we see, there are grave and serious violations of human rights that are, perpetuated by the corporate sector, whether you look at child labor, you look at the environment. And the reason why I want to highlight why this is significant is because in terms of when you look at the work of the Intergovernmental Working Group, you then find that it's the government of South Africa and also the government of Ecuador that initiates a process in terms of the elaboration of an internationally binding instrument. And these are two countries that are in the global south as such, that were able to find each other for us to actually have this. And this is then supported by various groupings or various countries within the council. And I think it's significant also because when you look at the Human Rights Council in itself, it is a body that is predicated on wanting to work on consensus, because there is general agreement that in the body, this makes the work of the council easier. But when consensus cannot be reached, we find resolutions that are brought to a vote, and which is exactly what happened when we find resolution 26/9. So from the very onset, we see that countries of the global south started this initiative. But when you look at also the general support in terms of resolution 26/9, there is a general divide in terms of who supports it and who doesn't. But we still continue to see that in as much as, yes, there won't be support in terms of other regions, or there is support in other regions, but we want to make sure that as we move forward, we all move forward together. And as Ecuador has been leading this process, I mean, with the support from South Africa and other like-minded countries, which include Cuba, you see Namibia, also Azerbaijan. And it's very significant because the various countries are able to find each other in this area of work. And it underscores that there's certain histories that we all share when it comes to business activities. And there's a certain, I could say, a collective trauma, if I could put it that way, that we all identify with, in as much as it may manifest in different ways. But there's something that, in terms of our understanding, that is similar. And that's why it's very important that these regional perspectives are brought into the fore when it comes to the Intergovernmental Working Group. So for us, as South Africa, in highlighting this, is that the reason I go through the history is because also we know too well, in terms of our history as South Africa, the effects of business activities on people. In this regard, when we see livelihoods of people or the well-being of the planet sacrificed at the altar of business profits, we cannot agree to this, because we believe as a country that business activities can indeed be undertaken in a context where human rights are protected. When you look at South Africa's foreign policy, it is underpinned by various pillars, but some of the pillars that I just wanted to highlight today is that it's a rule-based multilateral system, a developmental agenda of the African continent, but also South-South cooperation. So when we participate in the Human Rights Council, or in the work of the Council, is that we want to contribute to the development and strengthening of norms and standards to ensure the maximum protection of victims, the provision of effective remedies, and zero tolerance on impunity. So this system, we want to make sure that it is a rules-based, as I said, but also it's just and that it's equitable. And that is why we contribute to this process. And we've been an active member of this process in previous sessions of the InterGovernmental Working Group, because we want to see and make sure that rights holders are placed in the in the center of what is happening. We've always talked about a victim-centric approach when it comes to this process, to make sure that communities, peoples, marginalized groups who are at the center, we must make sure that in terms of the violations, they're at the center to make sure that they get the remedies that they deserve. Because as you know, and I think it's been expressed numerous times, is that in our region, especially in the African region, the activities of TNCs have had a great impact in terms of citizens, but also the environment. And I know that we'll probably, as we talk about regional perspectives, the spotlight will be on the Africa group as well. But the Africa group has also been a proponent of this process. And we deliver, I know for the past 2 years, it was 2 years before that, but in 2022, delivered a statement in terms of the Intergovernmental Working Group. And also we welcome the fact that we're seeing more and more African countries, even in the various regions of the continent, whether you look at Kenya, Ethiopia, Namibia, Egypt, that are becoming more active in the Intergovernmental Working Group. And then as I move towards the end, I just want to talk about the regional consultations when we talk about the Friends of the Chair. I know that there's a report that has come out where they've highlighted the different reports, if I could put it that way, that have come through in terms of the various regions when it comes to the Eastern Europe group, as led by Azerbaijan, in terms of what the comments that were made, where we see that most states were actually saying that the comments they've made in negotiations are still relevant. We see the WEOG also in terms of how they talk about the guiding principles, which we support. But as we have said before, that we need to move into stronger law. We see the Asia Pacific group, where led by Indonesia, where most comments also focused on the scope. I think Latin America and the Caribbean states was one of the most active, which gave, some of the comments. And for us as an Africa group, we have not had a consultation yet. So just in ending up and rounding off, what I want to say is that I think 2022 is probably one of the years that was very significant in terms of when it comes to this process and how this process will play forward. As you can see, I think there's been consensus was broken, if I could put it that way, in that session. And what I mean by consensus is that there was a general understanding in how things were moving and what is expected. But I think with the addition of the Friends of the Chair, the Chair's proposals, without clear indication of what it means, created a bit of divisions, and which I think if you were in Geneva, you would have noticed. So I think there is a bit in terms of the process, a trust deficiency that has been created, that has manifested, and we have to work at building that back. And this basically means that we need to build strong negotiation blocks at regional levels. And I think as we discussed this here today, that will help in terms of how do we do that. And I know that civil society has requested to meet with the Chair. I'm not sure if it has happened yet, but I hope also, because we have heard some of the concerns that have been raised, you'll be able to engage on those concerns. And we know that a new draft has been uploaded, and for us, in terms of this year's session, it's only 2 things in terms of that I will highlight. In terms of process, I think we want a clear negotiation that is done in good faith, because it's crucial for us in terms of this, in terms of making sure that this legally binding instrument comes right. Also, the Chair must bring clarity, and the Chair must bring transparency to the process. And as the Africa group, we'll also need to work in terms of making sure that we get also our group together to give the necessary components. And then in terms of language, we're still in consultation as a country, but we hope that we'll be able to engage effectively when we get to Geneva. I will leave it there for now, and thank you very much, Siko, and thank you to the conveners of this meeting.
Thank you. Thank you very much, Lihle, for joining us and for also highlighting that South Africa supports a treaty that places right holders at the center of a binding treaty on business and human rights. And now, before we proceed to the next session, to the next section of the webinar, I'd like to introduce our esteemed panelists, beginning with Ariella Scher, who is an attorney and head of the Business and Human Rights Program at the Center for Applied Legal Studies, which is located at the University of the Witwatersrand in Johannesburg, South Africa. She has previously worked as a legal researcher at South Africa's Appellate Court and as an attorney specializing in employment law and labor policy. Our other panelist is Sanyu Awori, who is an African feminist working globally to advance divisions, policies, and practice on economic justice. She currently works for Awori, a global feminist movement support organization, working to achieve gender justice on women's human rights worldwide, where she manages their work on building feminist economies. She has spent over the last decade working with labor, feminist, and human rights movements, advocating for economic justice, gender justice, and corporate accountability. Jaybee Garganera is the national coordinator of the Alliance to Stop Mining in the Philippines. He has been a co-convener of the Alliance since it was founded in 2005. Before focusing on mining campaign work, he used to head a rural development network and is one of the civil society representatives of the Philippine Council for Sustainable Development. On the panelist as well is Rachmi Hertanti, who is a researcher at the Transnational Institute, who focuses on energy and critical minerals, international trade and investment agreements. She is a member of the Asia Task Force for a legally binding treaty on business and human rights and is involved in several negotiations at the United Nations. Mai Taqueban is the executive director of the Legal Rights and Natural Resources Center, Friends of the Earth Philippines. She is on the executive committee of the Friends of the Earth International and is a co-convener of the Panakwisha Philippine Network to uphold indigenous people's rights. She teaches anthropology at the University of the Philippines, Diliman. Also on the panel is Soledad Garcia Munoz, who is the Special Rapporteur on Economic, Social, Cultural, and Environmental Rights from the Inter-American Commission on Human Rights, IACHR. She is a lawyer, a renowned academic and activist with a long career trajectory of regional and global work on human rights, gender, and women's human rights. She has provided professional and voluntary services to different agencies of the United Nations, to Amnesty International, to the Ibero-American Youth Organization, among other prestigious organizations. She is the first holder of Redeka's mandate after being elected by the IACHR in an Inter-American public competition. Ana Maria Suarez Franco is the permanent representative of FIAN International at the United Nations Human Rights System. Her main practice areas lie in the monitoring of public policies and in advocacy related to the human rights to food, the gender dimension of the right to food, and extraterritorial obligations of human rights. And finally, Danielle Sequeda, who is a lawyer in the Human Rights and Natural Resources Program at the Due Process of Law Foundation. He carries out research, advocacy, and outreach activities on human rights violations related to extractive and infrastructure mega projects and the international responsibilities of nations involved in these issues. Before joining the DPLF, he worked as a lawyer at the Inter-American Commission on Human Rights. The webinar will now take the form of an interview. I will ask opening questions and then specific questions that apply to each region and then a closing question. As some of the speakers have already noted, these regions that are represented are Africa, Asia, and Latin America. And they not only represent some of the most active countries in the binding treaty on business and human rights negotiations, but they also represent the most affected by human rights violations across the supply chain. And at the end, there will be an opportunity for the audience to ask questions to the speakers. You'll be able to do so by writing your questions in the Q&A box. And please do not use the chat function to write your questions. Rather, please specifically use the Q&A box so that all questions can be centralized. We'll ask you to please also write your questions concisely and in a clear manner, and to direct it to the specific speaker for the smooth running of the Q&A session. Now, my first question for 2 minutes each to the specific regions is, and directed first to Sanyu from the African region, is what is the most pressing matter in your region in 2023 that you believe a treaty can address? Sanyu, I'll hand over to you.
Thank you so much for having me be part of this discussion. I begin with Audre Lorde, who said, "There is no such thing as a single issue struggle because we do not live single issue lives, particularly on this continent. So instead, I invite you to consider this. The binding treaty can help us shrink corporate power that has been running unchecked in the region for too long. The extractive industry is wreaking havoc on the environment. Land is being grabbed and communities are being violently displaced. This is as attacks against defenders are high, and speaking out against the mining industry is literally the most dangerous thing you can do as an activist. We have powerful agribusiness companies who have captured our food systems and control what we grow and how we grow it. We have workers in supply chains across the continent, whether it's the garment, flour, or tea industry, systemically facing poor working conditions. So I'm unable to pick just one matter because the issue is that we're living under the tyranny of corporate power, where corporations have more wealth and resources than most governments combined. This alone is a giant red flag, but then add the context of our current global economic paradigm that prizes profit, that bottom line, above everything else, and also posits the private sector as key to economic development. Well, without binding standards, we're left with impunity when the human rights of people and communities are violated. Voluntary measures have proven insufficient, and we can only look to see in the COVID-19 pandemic that showed us how powerful corporations really can't be left to do the right thing. This is why, as feminists, we're calling for systems change, to shift power imbalances by elaborating on clear, binding rules for corporations and how they should behave, and the procedures to be followed when harm is caused. This will help us to close gaps on regulation. Thanks.
Thank you, Sanyu. I will now hand over to the Asian region, to Jaybee.
Thank you, Siku. Thank you to everyone. We're glad to be part of this conversation. From our experience from negotiating and documenting cases here in the Asian region, I see 4 important matters where the treaty can be significant and be meaningful, should it ever pass. First, there is the shrinking space for environmental and land rights defenders, as Sanyu has mentioned earlier. And unless a higher reference is made available, then states will continue with their impunity of either failing to protect and promote human rights of affected communities, or our governments will continue to be captured by the increasing influence of these corporations. And because of this shrinking space, it is really dangerous to be an environmental or land rights defenders. Second, with this climate change and the just energy transition being captured now by corporations, we are seeing an aggressive expansion of transition minerals in the name of achieving the just energy transition. This puts a new set of threats against communities and environmental activists. Therefore, new set of protection must be in place. And right now, the UN guiding principles are not enough. Therefore, a legally binding instrument is critical. Third, our corporations, as I've said, have captured many of our states. And I can name members of our parliament or Congress who are beneficial owners of mining companies or energy corporations or owners of large infrastructures. And I seriously think it's the same situation whether we talk about India, Indonesia, or the Mekong region. And so if our policymakers are in fact working for the agenda and benefit of corporations, the only way that a counterbalance can be afforded if there is a treaty that compels our governments to think twice or actually practice their mandate, which is not to protect the interests of corporations, but to ensure that their constituents are living a worthy, good life. Finally, a binding instrument is relevant, especially to ASEAN region, because I know of at least 5 countries who do not even have national human rights institutions. And therefore, there are countries that lack the institutional mandate to promote, protect, and fulfill human rights. While a legally binding instrument will not fill in that gap, a legally binding instrument will push forward at least the promotion and fulfillment of human rights. Thank you very much.
Thank you, Jaybee. I'll now hand over to the Latin American region. With Soledad.
Yes, of course. Hello, hola to everyone. Thank you very much for inviting me and for the opportunity to share this important webinar with all of you. We really need to generate many more spaces for exchange and action between Africa, Asia, and Latin America. Let me start by introducing shortly REDESCA, which is an autonomous office of the Inter-American Commission of Human Rights, created in 2017, 6 years ago, advance the economic, social, cultural, and environmental rights agenda in the hemisphere. In these 6 years, we have developed pioneering standards, cases on report on business and human rights, as well on Scher and environmental rights from a perspective of gender equality and intersectionality, focusing on the indivisibility and interdependence of all human rights. And at REDESCA, we observe every day the high impact of business activities on human rights, especially on Scher. Latin America has become the most dangerous region for the defense and promotion of human rights in the context of business activities, with a notorious increase in violence directed against defenders of territory and nature, particularly indigenous and women defenders, as Berta Cáceres in Honduras in 2016 is an icon of this sadly trend. In this regard, we welcome the inclusion in the text of the third revised draft of the binding treaty of the explicit protection of human rights defenders as victims of corporate action, as the Inter-American System and the Escazú Agreement to recognize. In the Inter-American System, we talk about the right to defend rights as a fundamental right protected in the framework of on business and human rights. On the other hand, I would like to stress the importance of the binding treaty reflecting the central role played by corporations in the degradation of the environment and the exacerbation of the current climate emergency, which is currently impacting not only the region, but the entire planet. And in this context, and as pointed out first in the thematic report on business and human rights, Inter-American Standard from 2019, and then in the resolution 3 from 2021 of the Inter-American Commission on REDESCA, which is the first set of a standard in the Inter-American System on this issue, the climate emergency and human rights. It is essential to recognize that business actions and practices have a considerable impact on the ecological balance of the planet, particularly through the emission of greenhouse gases, which contribute to global warming and the alteration of climate patterns. These emissions have a direct impact on the full realization and effective enjoyment of human rights affecting entire communities, especially those in situations of greater vulnerability, such as indigenous people, Afro-descendant, tribal and rural communities, campesinos. States then must ensure, for example, companies adopt plans to reduce greenhouse gas emissions from their products and services, as well as those of their subsidiaries and suppliers. Such measures should especially target those business sectors that tend to pollute disproportionately, as we can see constantly in America Latina, such as the fossil fuel sector and industrial livestock farming, which is linked to increase deforestation. We are in a really crisis of deforestation in Latin America, for instance, in the Amazonia, in Brazil and other in the Amazonic region. And also companies should publicly disclose their emissions, climate vulnerability, and risk of stranded assets, while not hindering access to justice, particularly for human rights defenders in environmental matters. That's all for now. Thank you.
Thank you very much, Soledad. I will now hand over to Danielle.
Thank you very much. I'd like, first of all, to thank Business and Human Rights Resource Centers and all those involved in this very important event, and also compliment my co-panelists, especially my colleague Soledad Garcia Munoz. So I'd like to also congratulate her for concluding her mandate with such an energetic fashion, and also all the assets that has been built throughout these 6 years of mandate. Thank you very much, Soledad, for all your efforts to put this inter-American agenda in way of addressing business and human rights also to a global sphere. Well, Latin America is a very important region to debate business and human rights. First of all, it's highly dependent on foreign investment. And in this scope, we have, unfortunately, several examples in which a binding treaty on business and human rights would provide better answers, complemented, but also somehow adding additional elements for the state's obligation compared to the guiding principles. For instance, my organization, ZPLF, has worked with several situations in which there is no international standard, or at least specific standards, to address, for instance, how should a state impose reparations in situations of that could be defined as ecocide. I'm from Belo Horizonte, it's a capital city of the state of Minas Gerais. Minas Gerais is where there were those 2 dam collapses by Vale mining company. The state of Minas Gerais made a sort of agreement with the company, and the company paid billions of dollars in reparations, but every single dime of this reparation were spent as a regular budget of the state of Minas Gerais, not to strengthen the capacity of basically overviewing and provide supervision on the operations of companies that could basically trigger another environmental disaster. So what's the standards applicable for this kind of situation? Is it possible, or there should be a sort of stringent obligation linking those kind of reparations to the prevention of new environmental disasters? So it's not clear at all, not either from the inter-American standards nor the guiding principle, the specificities of how should a company reparate this kind of ecocide. So we do believe that the experiences of the victims in the inter-American level will also be a very important asset to the debate in Geneva and the UN Human Rights Council to move forward with the treaty. And as you know, it was also mentioned here, Southern countries from the global South has been the one, basically the engine of the debate on this treaty. So we also rely on the capacities of governments in Latin America to move forward with this agenda and to somehow find a minimum standard that will not allow northern states basically to keep the baseline in the guiding principles and move forward with more stringent and binding obligations. In this effort, I'd like to also congratulate the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights for the very important precedents and judgments that have been issued that address specific components of the business human rights agenda that you won't find in the guiding principles and eventually can be even more, I would say, progressive than the current draft of the treaty. The Inter-American Court has issued, for instance, 2 recent decisions. One is related to a firework factory in the state of Brazil, and the other one is related to the activities of the Miskito indigenous people in Honduras. And those 2 judgments provide several elements that could also be very relevant for the debate in Geneva and on the Business and Human Rights Treaty. And finally, the report led by Soledad and ESCR rapporteurship at the Inter-American Commission on Human Rights brings somehow most of the standards of the universal and the European human rights systems, but add the victims focus that Soledad has mentioned. And on this regard, I would say that the Inter-American Commission on Human Rights has led somehow the necessity of addressing all those debates, centering the discussion on the position of the victims. So that's key for any debate on the Business Human Rights Treaty. I would stop here, and once again, thank you very much for inviting me.
Thank you very much, Daniel, and for the rest of the inputs, where it was basically highlighted that there needs to be binding standards, for example, to protect human rights defenders, especially in the context of a shrinking space to do so. And I would now like to move on to spotlight a specific region, and beginning with Latin America, with the following questions, and with 4 minutes each for Soledad and Ana Maria. The first question for Soledad is, how can a treaty help to strengthen the work of the Inter-American System of Human Rights? And what can civil society organizations do during the treaty process to help? Soledad, I'll hand over to you.
Thank you again, Zico, and a big hello to Ana Maria and to Daniel, of course, to all of you, but it's really nice to see you on the screen. I think it is a two-way question. As very well Daniel explained, the Inter-American system has a lot to contribute to this process and to the implementation of the treaty when it is adopted. And in recent years, the international community has made determined progress in addressing the growing role of business in respecting and guaranteeing human rights and the corresponding obligation of states in terms of action, prevention, and response to these challenges. And in this context, of course, the guiding principles have played a crucial role in establishing fundamental guidelines for global governance in this area. These principles have not only provided an essential frame of reference, but have also become a starting point, and I would like to emphasize these words. Starting points is not, of course, the final point of this evolution. We are trying to have a binding treaty, and it's the same in relation to the Inter-American system, but we, of course, need to recognize the importance of the guiding principle. In this regard, the Inter-American system is not new to the responsibility of companies about their duty to respect human rights. And as very well explained Danielle, we have very important jurisprudence now, both from the Commission and the Court, in relation to how business impact human rights, especially indigenous rights. And the issue has already significant evolution and continuous development, taking into account the needs and particularities of our region. The bodies that may act of the Inter-American System for the Protection of Human Rights, Inter-American Commission and the Inter-American Court, have recognized repeatedly various pronouncements that under certain circumstances, the international responsibility of the state may arise from human rights violation might committed by private parties, which includes companies. For this reason, it is essential to develop inter-American standards on the subject and strengthen the understanding on the indivisibility and the interdependence of all human rights. This is a real mantra for my mandate. The indivisibility in relation to recognize how companies affects the the human rights as a whole, human right to water, human right to education, human right to labor rights, trade union rights, housing, food, health, etc. And this is because I think it's so important also to consider the report on business and human rights, InterAmerican Standards, that we published in January 2020 as a substantial contribution to the comprehensive discussion of corporate responsibility in the area of human rights, and above all, the configuration of normative and policy initiatives at both the regional and national levels. In this report, we made recommendation not just for states, but also for business sector, also for economic actors, the international finances organization, and I think is an important asset, as Daniel said, for this discussion and for the binding treaty process. Of course, a binding treaty international instrument on the subject will help to consolidate the standards already created by the Inter-American System in the area of corporate accountability, as well as to strengthen responsible and sustainable business practices that contribute to the effective protection of human rights. Nevertheless, Redesca also encouraged that the thematic report on business and human rights, as I said, be read and analyzed as a relevant input for the dialogue and drafting of this treaty under discussion, in particular for specifying the obligation of both states and companies at a general level, taking into account the Inter-American experience, as well as for presenting important and innovative key advances in the region related to the statutory application of responsibility, the impact of corporate actions on climate change, and the disproportionate impact of human rights defenders. In addition, the standards on due diligence, prevention, and access to justice developed by the Inter-American System may represent helpful and consultative aspect of this initiative. On the other hand, it is important to highlight the fundamental role played by civil society organizations in the treaty process, including of course, the feminist movement. Since the very genesis of Human Rights Council resolution, that leads to the formation of the open-ended intergovernmental working group, NGOs has been participating in the negotiation process and side events on behalf of thousands of victims of human rights violation by corporate actions. In my opinion, this is the right time to build bridges of dialogue and convergence between the actors involved, such as governments, companies, and international organizations, while recognizing its several work in representing victims and fighting for access to justice. I also believe civil society can contribute even more if it participates in the broader spectrum of perspectives and debate. This would make it possible to reach a consensus and promote the ratification of a treaty that is perfectly in tune with the challenges inherent to this crucial issue. Thank you very much for your attention. I will have to exit in a while, but I really would like to thank you for the work you are doing and for this amazing occasion to meet all of you. Thank you.
Thank you very much, Soledad. I'd like now to hand over to Ana Maria. And Ana Maria, I'd just like to ask, what are Latin American civil society organizations hoping to see in the InterGovernmental Working Group focus on?
Thank you very much, Zico, and of course to the organizers and friends here, like Rachmi, Soledad, Jaybee, with whom we have been, and Sanyu, with whom we have been working along this 11 years of 10 years, sorry, of process, almost 10 years. My presentation will be a presentation of the collective knowledge. So it's not my knowledge, it's more what I have learned from people from the Global Campaign, the Treaty Alliance, the Feminists for the Binding Treaty. But of course, it is my version of it, and I do not pretend to represent a very diverse and creative region, but just to highlight some points. The question on what is important is, of course, focused or illuminated by three things that have already been mentioned here, but the other regions, including the priority of the affected communities, what in law we call the centrality of the victims. People affected do not love to be called victims, but okay, we will use this language here. Also, the importance to face corporate power. There is a campaign called the Campaign to Dismantle Corporate Power, not to dismantle companies, but their power. And of course, the importance to have clear rights for the people and also rules for corporations, what Vijay also mentioned. And within the points that have been defended in our region, I think what is the most important thing is how to ensure that corporate liability extends along the value chains and along the corporate networks beyond the territory of each state. The main problem we have is that the economy is globalized, but the law is nationalized, and this leads many gaps that impede the affected communities to access to justice. This includes, coming back to the report that Soledad presented, applying the pro persona principle that is a main principle of the Inter-American Human Rights System, which means giving priority to the person, giving primacy to human rights before investment and trade. And this includes also putting a very important focus on the emerging risks that we have through financialization, digitalization, artificial intelligence, and others. We also put a very big emphasis on all the damages that are related to the environment, to the right to healthy, clean, and sustainable environment. Unfortunately, the new draft is very poor on that. Many of the elements that were in the last version disappeared. Also very important is the role of women and gender and the differentiated rules that women and other gender trends need, similar to indigenous peoples and peasants. Unfortunately, peasants have disappeared from the new draft. On indigenous peoples and on women, we have very strong rules. Important also for us are collective actions. While almost all Latin American constitutions include some kind of collective or class actions, that this is not the case in the rest of the world, and we would like this trend to become global, because the power of the people, and especially the marginalized, is mostly collective. And also very important is the right to information. In many cases, people cannot access to justice because they don't know which companies are part of the value chain, or information on the violations that only the companies have. Very quick, we want that this treaty is not only on due diligence, but on bigger prevention and liability, including civil, administrative, and criminal liability along the value chain or the businesses' relationships. And of course, including these extraterritorial judicial jurisdictions where the home companies are, but also where the assets are that are needed to remedy the people. And also dismantling some hurdles that people have to access to justice, like, for example, the burden of proof, which should be reversed, the forum non-convenience, any judge should deny justice based on their national norms, or ensuring forum necessitatis, which means that people should be able to access to justice, not only in the countries where the violations were originated, but in any other in case they cannot access to justice in the home or host country. And finally, and very important on the implementation, we all ask for different ways in which people can claim against these companies. Some of the groups defend the idea of an international treaty on TNCs. Others speak about a reinforced treaty body. Others speak about the possibility to extend the jurisdiction of the International Criminal Court. And this is an aspect where we are now very weak in the current draft, but I think for the region, this is key. So I would let here on this question. Thank you.
Thank you, Anna Maria. Just one more question as well. Would you please highlight one revision contained in the updated draft of the treaty that is particularly pertinent to your region, and also just explain why?
Yeah, I will take time to mention three very shortly. The first one is Indigenous peoples are strongly represented, and the free, prior, and informed consent is in sight. Unfortunately, peasants are now out, so this is problematic. Second, very relevant is the participation of affected communities and marginalized groups in the definition of reparations, but also in the definition of laws to ensure prevention. This is a new element that we didn't have before. And maybe a third one that I wanted to mention, a bit problematic, is the applicable law. While in the Article 11, it is clear that the victims could select the applicable substantial law, which means, for example, a victim in Ecuador could select the Ecuadorian law to be applied, which is more beneficial than, for example, American or German law, because it contains economic, social, and cultural rights, which is very good. On the other side, in the scope, it limits the scope to the treaties that have been ratified for the states parties. So it's like, we don't know if one article will neutralize the other, and this is problematic, but we have to work on this. I have many others. I would not stop here, but I just want to say that mentioning some one or three or two positive aspects is not a holistic analysis of the new draft. I think we have to balance and to see all the elements, and maybe just this very specific analysis of 3-4 good aspects does not give an entire integral view, and it's still pending in my organization, and we are on the work with the movements on that. So I hope that we will have opportunities to share more in the coming months. Thank you very much.
Thank you, Anna Maria. And this is a question for Daniel. How do you see the draft treaty in relation to the protection of vulnerable groups, such as Indigenous peoples, who have been one of the most impacted by extractive activities in Latin America? Over to you, Daniel.
Thank you. Well, just as Ana Maria said, the treaty contains different provisions on Indigenous peoples. I have counted at least 6 mentions to Indigenous peoples in the current draft, from the preamble to also through all the substantive provisions, which is very important, and it's an added veil to the debate. However, I would like to bring again a standard that's recent at the inter-American level, but it's quite old at the universal level, at the UN level, which is the right to self-determination. The FPIC, which is pre-prior and informed consultation and consent, is there in the draft, but there are certain aspects of Indigenous rights that should not be addressed only as a FPIC, with an FPIC dimension, I would say. For instance, the right of an Indigenous community to consult themselves without the participation of a state, what is known in the inter-American level or the Latin American as a auto-consult or self-consultation. Is the draft endorsing this kind of consultation? The Inter-American Commission on Human Rights does endorse in a recent report named The Right of Self-Determination of Indigenous and Tribal People. It was published in late 2021. That basically reshape and somehow bring to the inter-American level the standards developed at the universal level. The Indigenous Peoples Declaration of 2007 from the UN General Assembly is much more centered in the self-determination rather than FPIC, rights of Indigenous peoples. So I think it's a good advance in the draft to have Indigenous peoples as a focus group that's frequently victims of corporate abuse. But I would say that for the next draft, I would love to see a more stringent language such as self-determination there. I know it's a very polemic debate. It won't be that easy to obtain any endorsement from the northern countries. But in the end, it's the current international law. It's basically the nowadays standard that's endorsed by the UN since 2007. At the OAS, we have a American Declaration of Indigenous Peoples' Rights from 2016, and the Special Rapporteur on Indigenous Peoples' Rights in UN, and also the InterAmerican Commission have moved forward with the agenda, basically trying to detach from the dependence on or reliance on FPIC and moving forward with more, I would say, stringent obligations of states to respect the autonomy of indigenous groups to decide on their own interests, any economic priority that they have for their territories and natural resource. So I'd love to see the debates moving forward. And I have seen my own indigenous groups from Latin America and Africa demanding the Human Rights Council and the working group to adopt a more specific language on self-determination. Let's see how it will end.
Thank you very much, Daniel. And now to also put a spotlight on the next region, Africa, for 4 minutes each. A question for Ariella first. Ariella, last year at the negotiations for a treaty, the chair rapporteur appeared to suggest that the delay around producing a new draft of the treaty was due to the African region not electing its own representative to the Friends of the Chair grouping. What has happened in the region since, Ariella?
Thanks so much, Siko, and thanks for the conveners for having me on. I think it's helpful to refer to what Ms. Mabuza said when she said that at last year's negotiations, there was consensus was broken. And that's largely through this establishment by the chair rapporteur of this Friends of the Chair grouping. There's no mandate, legal mandate in the resolution for him to do that. So it was all a little bit confusing. And then, as you said in the question, there was no nominee from the African region, and in correspondence and during the negotiations last year, the chair rapporteur seemed to suggest that certain delays, perhaps the absence of a revised draft of the treaty last year, was down to this. On the very final day of the negotiations last year, it was announced that Cameroon was going to be the representative for the African region in the Friends of the Chair. And then the way that that followed on was that there was correspondence from the chair rapporteur earlier this year, saying that there was going to be these intersessional meetings that would be convened by the representatives for each region in the Friends of the Chair grouping. And then also, as Ms. Mabuza referred to, the African region to date is the only one of the regions that hasn't met for this intersessional consultation. The other regions have met. Alongside the new draft of the treaty, the chair rapporteur released this report into the different intersessional meetings. And of course, just to flag an issue with those intersessional meetings is that they were limited only to state engagement. There was no space, therefore, for engagement by CSOs, by communities, by labor unions. But nonetheless, the African region has not yet met. And I guess the question for us as CSOs and communities on the ground is what is happening here? Is this a failure to meet? Is this a rejection of the Friends of the Chair grouping because its legitimacy is in question? If we don't know what its legal status is, we don't know what its mandate is. It seems, as has been referred to, that the chair is operating this parallel process. You know, there's what's happening in the negotiations, and the process was largely limited to what was happening in that week of negotiations until, say, the past 2-3 years. But now there seems, as I said, to be this parallel process, this introduction of the Friends of the Chair grouping, this chair's recommendations or chair's proposal, which has now been, some of those have been incorporated into the revised draft. And for us, as I said, as African CSOs, we've both the African states themselves that have been engaging in the negotiations for the past over a decade, as well as CSOs, communities, labor unions, we've really supported this process and we've held it together. And to now have this questionable forum of the Friends of the Chair in which we're not sure if African states are participating, there doesn't seem to be any communication. But we support this process, but we support the legitimate version of this process. And if we as the African region consider that that Friends of the Chair grouping is illegitimate, then we must make that clear. If we alternatively are happy to go along with it, then we must support the extent to which it can work towards a stronger binding treaty and not a weakening of the treaty in favor of corporations. So that's where we stand at the moment. It is quite a strange place, and it's not a great answer, but we've still got about a month and a half before everyone gets to Geneva. So we've got time to come out with a strong position and to understand what it is that we can do to support our states in getting towards a strong treaty.
Thank you very much, Ariella. And my next question is for Sanyu. Sanyu, what are African civil society organizations hoping to see at the InterGovernmental Working Group in 2023?
Thank you. So a couple of months ago, we had a binding treaty in Daba convened in Johannesburg, South Africa, where we had a chance to consolidate our position as African civil society. And it's clear that we want negotiations to really focus on spelling out the obligations and duties of corporations, including punitive measures for violations. We also want there to be express recognition of the rights of communities to say no. And this is in addition to the standards on free, prior, and informed consent. And we also want there to be clear rights-affirming procedures and guidelines on how victims and affected communities can access remedy. The right to redress and reparation is an explicit and loud demand that rings throughout the African region.
Thank you very much, Sanyu. Moving on to the next region, the Asian region, for 4 minutes each, and beginning with Rachmi. Rachmi, what are the Asian civil society organizations hoping to see at the InterGovernmental Working Group during the negotiations?
Thanks, Zico, for the questions. I think we from the Asia Task Force for Legally Binding Instruments actually have discussed several matters at the regional consultations event that we had in Jakarta last August. So I think we try to highlight some emerging issues, particularly on some contentious issues that Jaybee has mentioned earlier. But this year, actually, we expect that how the Asian state itself can take the active role in the negotiations in shaping the binding human rights protections, especially in the midst of increasing global geopolitical pressure on southern countries. Because we know that the situations has greatly influenced the dynamics of changing political positions, especially for southern countries, in various negotiations process at the UN, including the negotiations of the legally binding instrument on transnational corporations. So I guess the emerging trends in southern countries, particularly like in Asia, for example, like the strengthening of the nationalizations and self-determinations agenda, which is actually very well reflected on the issue of the right to development, I think should be also be highlighted on how it will implicate the positions of many of Asian states in the negotiations process in Geneva later. And because then we are questioning how are these arguments actually anchoring the people's needs, for example, and or are these short of global South perspective, also driven corporate model, like Jaybee mentions that we have more intense of extractive industries that seeking for more critical minerals, for example, for energy transition, etc. So that's why for the Asian task force itself, I guess this year, because we are the advocacy platform and collective campaign for LBI in Asia, there are at least several important agendas that must be pushed through this year's negotiations by Asian groups. First, I think the LBI process at the UN should be an arena to support and amplify the existing struggle of the people against the exploitations of transnational corporations' business abuses. Second, the treaty itself should emphasize the rights of victims. How should we have more concrete outcomes of the negotiations about the some articles related to the rights of victims? And the third one is the treaty should be primarily for transnational corporations to make them accountable. Therefore, the treaty should focus on TNCs and other business enterprise with a transnational character, with a strong legal liability provisions, particularly on joint and several liabilities. I guess these three agendas have been agreed during our meeting in Jakarta as our strong positions from the Asian task force itself. Thanks.
Thank you, Rachmi. My next question is for Jaybee. Jaybee, how well are affected communities represented and protected in the current draft of the treaty?
Thank you, Siko. I can give a few thoughts, and I will also invite my colleague Mike to add her thoughts. I think there's a good representation on the interest and agenda of indigenous community. However, as Ana Maria mentioned, peasants and has been taken out. And then there's practically no mention of victims of climate impacts. And then we're not sure yet of how women and gender is going to unfold in the negotiations. But if we're asking qualitatively, I think the current version that we have right now that was issued last July is very, very far from the ambitious draft that we are expecting. I'll invite my colleague Mai to share her thoughts and share our 4 minutes. Thank you.
Thank you, Jaybee. I think you presented a lot of the issues where communities are concerned, and certainly, we belabor the point that the premise for the need for a legally binding treaty that ensure and protect the right of communities is certainly necessary. It is also fairly common. I just want to bring back the fact that majority of the states, especially in the global south, that our national authorities really lack the essential administrative, judicial resources, and has been belabored enough in this process, the political will to appropriately safeguard communities versus transnational corporations and their extensive global chains. Just to add, in the treaty process, how very often community rights are undermined is that in the negotiation, we're sharing the space with advocates for business as well. So that always brings forth this tension or this competition, and very often the particular and the disproportionate impact of business-related human rights suffered by the communities. And I quote that directly from the treaty, but how that is actually unpacked in the treaty provisions, that's still quite lacking. I share the concerns of our panelists that as we move forward, we're taking a few steps back. And certainly more things need to be done in terms of articulating rights of communities in the drafting of the treaty.
Thank you, Mai. And also a follow-up question for you as well, while I have you. How would the treaty change the fight for access to remedy for indigenous communities that you support in your work?
Thank you, Siko. In countries like the Philippines, many transnational corporations operate in ancestral domains of indigenous peoples. Extractivist in nature, they have undermined indigenous people's rights. And while indigenous peoples have taken on the frontline defense of the environment, they have remained the most marginalized and underserved sector. Many of those under threat suffer violence. The target of SLAPP suits killed have been, in fact, indigenous peoples. Domestically, the access to justice of Indigenous peoples have been challenged, if not unavailable. This panel, again, has belabored this point emphatically enough. So a treaty that ensures their active and meaningful participation in the processes is certainly long overdue. Moreover, a treaty that ensures not just the internationally recognized standards of free prior informed consent, as Daniel has said earlier, adds a layer of protection and promotion to that, but also appreciating the dynamic evolution of how free prior and informed consent also manifests among Indigenous peoples. Domestically, interestingly enough, the recognition of FPIC is available in our national law, but this process has been reduced and interpreted as mere administrative consultation, when in fact it is an act of self-determination. Equally important is the right to redress, meaning vindication and justice. Punitive provisions must be incorporated in the treaty. This has been very elusive for Indigenous peoples, where atrocities perpetrated against them has been conflated with national investment defense. So a proper legally binding treaty, a meaningful one, can actually help enable Indigenous peoples to craft their own development pathway. Thank you, Siko.
Thank you so much, Mai. And now for the closing question, with the remaining regions, which is Africa and Asia, for 2 minutes each. Directed the first question to Ariella. Ariella, can you please highlight one revision contained in the updated draft of the treaty that is particularly pertinent for your region, and please do explain why as well?
Thanks, Siko. I think a lot has been said by the other panelists about particular aspects of the treaty. But for me, the overarching issue here is that this is not the treaty that we want. This is not the treaty we've been negotiating towards. And that for me is really important. The particular new revised draft of the treaty has a lot of additions referring to human rights due diligence. Now, human rights due diligence is really important. It's necessary, but it's not sufficient. And it seems to be this attempt to pivot from a binding treaty that governs transnational corporations to a much softer instrument on human rights due diligence. And I think it's important to note that the African states that are directly and very robustly involved in the negotiations have never referred to human rights due diligence. That's not our concern. It's been brought up particularly last year at the negotiations by European states and the European Union that's not actively involved in the negotiations because they apparently don't yet have a regional mandate. So I think it's important to highlight what's included in this current draft, but also what's been left out. Who was and wasn't listened to when they were bringing their statements before the working group last year. And that's something that's very clear in this current draft and formally was not brought up by any of the negotiating parties. Thank you.
Thank you, Ariella. To the Asian region, Rachmi.
Yeah, I think from many issues that have been raised in the new draft of the text itself, I guess the issue of the scope is still become one of the major issues, particularly for the developing countries or some Asian countries itself. So for the Asia Task Force, actually maintaining the scope of transnational corporations and other business enterprises with the transnational character is vital for preserving not only the future of treaties effectiveness, but also the democratic nature of the process. And I know that with the transnational character as the scope, I guess then it's really important how the treaty itself later must then set a comprehensive and adequate framework of overall joint and several liabilities along the value chains that serve as a mechanisms to ensure that all parties involved are held accountable. So I guess that's the strong positions for the Asia Task Force beside on the rights of victims itself. I guess Mai and Jaybee have been shared about the important elements that should be discussed under the rights of victims itself. So I guess that's the point from the Asian perspective. Thanks, Zico.
Thank you, Rachmi. Mai, can I hand over to you? Mai?
Thank you. I will just really echo what Rachmi has said. There's been a lot of conflation, a lot of issues about business and human rights guiding principles. And what we really need from this legally binding treaty is one that could really gather or impose larger accountabilities on transnational corporations. We've had so many business enterprises operating in the Philippines, in the region, that after one violation or another, they simply leave the country, leaving in their wake massive destruction to our environment, a lot of communities without reparation. And this has been, it's a whole process of decolonization still. And we see the legally binding treaty as something that concretely does answer to some of this issues of historical marginalization of our communities, as well as of our natural resources.
Thank you very much, Mai, and thank you to all the rest of the panelists. I will now hand over to Elodie for the Q&A, but before I do, I think it's important to summarize some of the interesting points the speakers have mentioned, and especially as it relates to when looking at the entire current draft, to make sure that we're able to assess not just what's new, but also in conjunction with everything else in the draft. And some speakers highlighted that there's now due diligence that has been included in the current draft. And as Ariella said, this is a position that's mainly being pushed by the European states and not by the African states. And also, as Anna Maria mentioned, the treaty aims to achieve something broader than just due diligence, especially as it relates to the African states. And the treaty, for example, includes extraterritorial obligations, which ensure that obstacles in accessing remedies are removed. And some speakers have also highlighted that these obstacles, for example, include ensuring that there's binding legal obligations on direct obligations on transnational corporations. Thank you very much for allowing me to moderate today. I will now hand over to Elodie.
Thanks, Zico. Hi, everyone. So thanks for people who've already put their questions in the Q&A box. So if you can continue to do so rather than using the chat, as Zico was saying, so we have all the questions in one place, that's easier to manage for us. And if you can also direct them to a specific speaker. If you prefer to ask a question orally, please raise your hand and we'll keep an eye on those as well. So just to start with a first question for Daniel, what kinds of sanctions might a binding treaty establish in order to underlie enforcement of the treaty on states and on transnational corporations?
Sorry, I got a problem with my connection. Could you please repeat the question?
Absolutely. So it's about what kinds of sanctions might a binding treaty establish in order to underlie enforcement of the treaty on states and on TNCs?
Okay. I would say that in terms of reparations, international human rights law provides a lot of sanctions and kind of reparations that can be placed upon states. The main question is how should those reparations entail specific sanctions that the state should impose to companies? We have a set of case laws in the European human rights systems, but the European Convention on Human Rights is quite short in terms of the mandate of the European Tribunal of Human Rights to establish reparations. It's mostly compensation measures. In the Inter-American Court of Human Rights, American Convention on Human Rights in Article 2 provides a broader mandate for the Inter-American Court to establish reparations upon states. As you know, international human rights tribunals do not have mandates to impose straight reparations upon companies. But under international human rights standards, the obligation to prevent and also to ensure human rights impose specific, I would say, obligations that states should apply towards private actors, which includes for sure companies. In this sense, I would say that a minimum would be a provision in which companies should not compensate the state basically in a sort of duty-free fashion in which the state can do whatever they want with this kind of compensation. The specific example I gave in my home country in Brazil is quite astonishing because the company paid, I think in dollars would be $3 billion for the reparations of the worst environmental damage ever taking place, not only in Brazil, but worldwide. And the state of Minas Gerais, where I am from, spent all this money in regular budget, paying civil servants basically for regular use of the money, not a single dime to prevent further crimes such as this. So I would say that the draft treaty could add some specificities based on international human rights standards in terms of reparations, and also try to tackling the possibility that companies will basically pay this kind of compensations or this kind of reparations, and there will be a sort of incentive for companies to keep doing that, because in the end, the state will take advantage of the possibility of basically filling the gap of its budget through compensations paid by companies committing these kind of ecocides, for instance. So I would say that there should be a dialogue between the international human rights standards on reparations upon states and by default, also the sanction that should be imposed upon companies. And very briefly, also the case law of the Inter-American System, I think it should be more specific in terms of what should states do upon companies involved in human rights abuse. There is a broad, I would say, set of obligations, but not specific ones, for instance, established that non-repetition measures is also applicable to companies. We have never seen that in the past, not only for states, but also for companies. Any sanction imposed upon companies should also take into consideration the non-repetition measures, which is basically a category of reparation that's not only established in international human rights standards, but also in international public law. The draft articles on state responsibility mention specifically the non-repetition measure as a category of reparations.
Thank you, Daniel. And so now there's another question for Sanyu. And I think it was linked to your first intervention because you mentioned the extractive. What would your expectations be towards businesses engaged in mining or buying raw materials to resolve human rights breaches? And do you have any concrete measures in mind that they should implement?
Thank you. I want to start by saying that many communities challenge the concessions and the terms and conditions that mining companies have even been allowed to operate in the region. We recognize that there's an inequality of arms and there are billions of resources lost to illicit financial flows and tax injustices. And I think it's important whenever we talk about breaches to put everything into this broader context. The expectation is that whenever there is a breach, for there to be the right to remedy both for individuals and for communities to be able to bring claims as a collective. And I loved my colleague who talked about non-repetition as part of reparations, because this is also a key demand. We want, when there are breaches, for companies to pay attention to how women and indigenous groups and other minorities have been affected. It's really important to engage the nuances there and the interconnected ways structural discrimination conspires to disenfranchise certain groups, especially when it comes to their rights and their collective rights to land. And we want that accounted for whenever we're talking about remedy. It's also important for companies not to preclude or stifle or intimidate the right of communities to seek justice in the courts. Very often we find that when communities engage in consultations or operational level grievance mechanisms, they are precluded from then seeking justice in courts. And that's something that we seek to challenge. Also, it's important to recognize that why is the mining sector the most dangerous sector for activists to challenge and speak out loud publicly? How are companies making sure that they are defending the defenders and addressing the fact that so many mining regions are accompanied by heavy militarization that then are complicit in the human rights violations? How can we address that and shift things? So that's just some of the asks around mining companies.
Thank you, Sanyu. And we have another question. It's not directly to any speaker specifically, but it's an interesting point that hasn't been made before. It's about the coverage of the binding treaty negotiations in the mainstream media, because, you know, we haven't heard so much about it in kind of mainstream media. So the question is how to involve the media, especially mainstream media, to promote the negotiations, because it's something that hasn't been discussed at all. So if, you know, is there a volunteer to, okay, Jaybee, thank you.
Yeah, thanks for that question. You know, in the several times that we've been in the negotiations, there were several media briefings and there were creative actions. In fact, in the broken chair, which is an outside action, at the gate of the UN headquarters in Geneva, and even inside action. And those are pegs where media has taken notice and reported on it. But I have to agree, there is very low media coverage, primarily because, you know, this is a negotiation. And I think the media is looking for a handle that is more newsworthy. And this is where the case documentations, the actual community experiences, and the voices of the affected communities come into play. I think there's also some media coverage on how business and large corporations are trying to frame why a legally binding instrument will be problematic for the World Economic Order. So yes, there is very low media coverage, but I think it's a factor of, one, the negotiation itself is so technical and not that newsworthy in the context of what's worthy of mainstream and social media right now. And number two, I think those media that are covering the negotiations are very limited in scope, mostly in Geneva, and if it's in international news, they are looking what is the angle that they will have to present the news. And right now, I think the only compelling story is the resistance and struggles of communities, and most of the times, the editors or producers of mainstream media will not find those stories palatable to be presented or published.
Thank you. And we are running out of time, so I'm just going to take one more question, and perhaps for Ariella, but again, you know, May or Rachmi, you're you know, also welcome to join in. But it's really about the fact that the treaty is like an ideal instrument, and so there are different regional positions. So how would you kind of overcome challenges of avoiding provisions that are too prescriptive or, you know, intrusive on the domestic law of state parties, and that may not necessarily provide for all of the concepts or principles involved, and so therefore that could make the treaty very difficult to implement?
Thanks, Elodie, and thanks for the question. I think we need to recognize that the treaty is the reason we're having this process is because it is incredibly hard for a lot of states, particularly states in the global south, to themselves independently stand up to these really powerful, really well-resourced transnational corporations. So this endeavor is hard, and that's demonstrated in the extensive negotiations. I can speak particularly from the African regional perspective that very excitingly earlier this year, the African Commission on Human and People's Rights released a statement recommending that at least at a regional level, African states start working towards a treaty governing transnational corporations. And so at least at the human rights mechanism level in our region, there seems to be consensus there. But the role that all of our states have, and that falls on their representatives every October, is to develop and to strengthen that consensus in Geneva. And ideally, in order to do so, you want a very strong chair, but a chair who is in favor of the movement towards a strong binding instrument that really brings to the fore the rights and the needs of peoples and the obligations of companies and then the states. But it is a political process. There are pros and cons to that process, but our focus needs to be on achieving consensus in the right direction.
Thanks, Ariella. And we're 1 minute over, so I just wanted to thank everyone that participated in this webinar, our speakers, Siko, our moderator, also our co-organizers, the Center for Applied Legal Studies, the International Commission of Jurists, Justica Ambiental, Lawyers for Human Rights, and the Zimbabwe Environmental Law Association, and of course, all of you who attended this rich discussion. So we hope you've enjoyed hearing from experts from different regions and also their take on how a treaty can address specific issues related to their region. We'll continue the discussion on the treaty with our last webinar in the series. It's going to be on the 19th of September on access to justice for affected communities. We'll send the invitation early September, and we hope to see many of you at that session as well. Thanks again for attending. A recording will also be available for the session. Thank you very much and goodbye.
Thank you.
Thank you. Thank you.
Thank you all.